Today we will go through some of the most recent judgments delivered by the Court of Justice and the General Court, and I will focus on those who I believe bring new elements to the debate, or at least consolidate the already existing ones. As a general subdivision, I will distinguish between the two main types of actions when it comes to EU sanctions. The first is the action for annulment, of course, and the other action is the action for damages. Coming to the first category, I'd like to start talking about one very interesting judgment, which is the Benali judgment, which was rendered on the 28th of October 2020 by the General Court. As a brief reminder, the Benali judgment concerns Mr. Benali, who is a Tunisia citizen, and he was concerned by the restrictive measures in view of the situation in Tunisia. His initial entry was by acts of 2011, and he was afterwards maintained on those lists on a yearly basis. This case concerns the application which Mr. Benali lodged seeking the annulment of namely decisions 2018-141 and 2019-135, by which the Council had maintained his name on the contested list by providing the same reasons supporting the original listing. This case I have chosen because not only because of the merits of it, but also from a procedural interesting point, because in this case, Mr. Benali had had lodged an application for legal aid pursuant to Article 146 of the Rules of Procedure of the General Court. And as you know, an application for legal aid has the effect, among other effects, to suspend the time limits for lodging the application. What happened in this case, that while the General Court, while the proceedings concerning the legal aid was not yet ended, a new decision was adopted by the Council, which was decision 2019-135. And therefore, before ruling on the substance of the case, the General Court ruled on the admissibility of the action insofar as it was directed against this second decision. And more specifically, it dealt with the question whether, for the purposes of assessing compliance with the time limit for bringing an action, it must be held that the suspension of time limits for bringing procedures resulting from the application for legal aid relating to the 2018 decision also applied with regards to decision 2019-135, insofar as the application sought the annulment of both decisions. So this case is very peculiar because normally a legal aid request cannot concern hypothetical acts. And in this case, of course, the 2019 Act was not yet adopted when the applicant has asked for legal aid. So one could have immediately said, well, of course, this act did not exist. So I cannot expand my request for legal aid, and I will have to follow the standard rules for lodging a new application when a new act will enter into force, and I am in the position to contest it. But of course, when it comes to applications, we know that the rules of procedure have provided for a specific provision, which is Article 86, which allows applicants to amend their original request and to modify it, to lodge a statement of modifications. And the General Court said that in this case, this was also possible when it came to the legal aid application, because it was not important, it was not possible for the person to be somehow discouraged in bringing a new application if he had to lodge a different and separate request for legal aid. So the General Court held that the time limits for dealing with the applicant's application for legal aid could not have the effect of restricting access to the courts of the European Union, and concluded that the suspension of the time limits for bringing proceedings also applied to the application as directed to the second decision. As regards the substance of the case, the General Court in the first place retook or developed the considerations already derived from judgment of 19 December 2018, the Azarov versus Council, case C 530-17P, and therefore stated that the Council was required first to verify that the applicant's rights of defense and his right to effective judicial protection had been respected in the judicial proceedings concerning him in Tunisia. And secondly, to state the reasons why it considered that those rights had been respected. In that sense, the General Court added that the Council's obligation of verification is unconditional. It is true that in earlier judgments, and I'm referring in this sense to case Mabruk versus Council, case T175-15, and case Eds versus Council, case T288-15, the General Court pointed out that in order to maintain the designation of a person on a list, the Council had only to gather evidence of the existence of an ongoing judicial proceedings concerning the applicant in the case. And it was required to carry out additional checks only where there were factors raising questions concerning the respect of the applicant's rights. Of course, these cases were prior to the judgment rendered by the court in Nazarov versus Council. So in the present case, in the Benali case, the General Court made application of the principles derived from this latter judgment, and it noted, moreover, that the applicant's right to a decision within a reasonable time is a fundamental component of a right to an effective judicial procedure. And it was for the Council first to make sure that it had sufficient information concerning the state and progress of that procedure in order to assess the risk of an infringement of such right. And secondly, to carry out such an assessment with care and impartiality in order to draw the appropriate conclusions. In the present case, the General Court finds that the judicial investigation on which the applicant's designation on the list at issue was based in 2011 had been opened since then without having given rise to a judicial decision. And moreover, the information that the Council had at its disposal made no mention of any procedural act or any other act whatsoever which was specifically concerning the applicant. In the absence of such information, the Council was therefore not in a position to properly assess whether the Tunisian authorities had complied with the applicant's rights to be tried within a reasonable time. And therefore, the General Court concluded that the Council made an error of assessment and annulled both decisions. So decisions 2018-141 and decision 2019-135 insofar as the applicant was concerned. Another interesting case I would like to talk to you about today is the case, two judgments of the 10th September 2020 in the Hamas cases, where the court held that the Council may maintain a person or an entity on a list relating to freezing of funds if it concludes that there is an ongoing risk of that person or entity being still involved in terrorist activities which justified their initial listing. The persistence of such a risk may be established in particular by reference to the national decisions which justified the initial listing when that decision has recently been reviewed. And following such review, it has been concluded that the continuation of the listing of the person or entity is justified on the ground of recent incidents demonstrating that that person or that entity remains involved in terrorist activities. Such a review is intended to ensure that the Council's decision is taken on a sufficient factual basis which enable the Council to conclude that there is in fact such a risk. One interesting point that I would like to underline is that, of course, in the present case, the court found that the Council established that there was still a risk that that organization would be involved in terrorist activities. And it based itself on the re-examination of a decision of the United Kingdom Home Secretary, which occurred shortly before the re-enlisting in 2014, and which were then, in relation to the date of adoption of the Acts 2015, very recent in nature. So this element of the recent information at the disposal of the Council comes back frequently in the case law of the court and the General Court. It was also interesting to note that Hamas submitted that this decision of the United Kingdom Home Secretary was not a relevant decision because could not be considered as emanating from a competent authority. However, the court found that the concept of competent authority covers not only judicial authorities, but also, if they have competence in the sphere of combating and tackling terrorism, as well the equivalent competent authorities in that area. Accordingly, the court did not rule out the possibility that decisions taken by the authorities other than judicial ones may be regarded as decisions taken by a competent authority, which can be taken into consideration by the Council the moment it reviews the listing of the concerned person. Another important thing is as regards Hamas' argument that the Council was not entitled to use evidence indications which it had made in the context of other proceedings. Suffice was for the court to recall that the prevailing principle under EU law in the context of restrictive measures is that of the unfettered evaluation of the evidence, so that the parties in principles are entitled to rely on evidence of any kind in order to prove a given fact. Going now to restrictive measures taken in view of the situation in Syria, I believe that the Kadur judgment I'm going to briefly talk to you about right now is interesting because of the evaluation of the single criterion for listing a person. Because in this case, the General Court found that the benefit received from or the support provided to the Syrian regime is an autonomous legal criterion, which as such is to be distinguished from that of a leading business person operating in Syria, or even that of a person associated to figures belonging to that regime. Why I believe this is important? Because it is, of course, sometimes very difficult to distinguish which are the elements proving one criteria or another, because for certain cases there may be a certain overlapping. What the General Court has stated in this case is that where the Council decides to include or retain a person's name on the listing question, it must determine, in light of the evidence it has at its disposal, the category or categories into which that person may fall. And in that connection, it must consider first which criterion or criteria it intends to use in order to include or retain a person's name on the list, and secondly, whether it has a body of sufficiently specific, precise, and consistent evidence in order to establish that each and every one of the criteria he has chosen are in fact fulfilled. In that sense, the Council may, in any review prior to the adoption of measures retaining a person's name on the lists in question, determine on the basis of the substantial evidence or observations which are submitted to it, whether the factual situation has changed since the initial inclusion, and of course, evaluate whether changes in the factual situation warrant that this person is no longer to be maintained on those lists. As regards the relevance of the evidence submitted by the Council, the General Court found that in order to justify retaining a person's name on the list in question, the Council is not prohibited from basing its decision on the same evidence justifying the initial inclusion, re-inclusion, or previous retention of the applicant's name, provided that first, the grounds for inclusion remain unchanged, and second, the context in which those measures have been adopted or maintained have not changed in such a way that the evidence is now out of date. And this conclusion is, of course, in line with the idea that the measures adopted in the context of the common foreign security policy are subject to a periodical review and may be applied repeatedly in subsequent period. The Council must therefore be allowed to continue to apply the necessary measures as long as they are needed, even if the situation has not changed, provided that the facts which form the basis for maintaining the restrictive measures continue to justify their application at the time of their adoption, in particular when there are facts that are sufficiently recent. Going on now with another interesting judgment rendered on 17 September 2020 in case C73218P, Rosneft and others versus Council. I believe that this is a very interesting case, which I was specifically, moreover, requested to talk about, because it has several elements that are interesting for the future, I would say, and also for the ongoing situation when it comes to the review of the legality of the restrictive measures. Just to give a little element of context, this case was brought after that in 2014 the Council adopted restrictive measures in relation inter alia to the oil sector in Russia in response to the actions taken by Russia to destabilize the situation in Ukraine. Those measures included, in particular, prohibitions on the export of certain sensitive products and technologies, and restrictions on the access of certain operators in that sector to the EU capital market. A number of Russian companies that were members of the Rosneft group, specializing in the oil and gas sectors, brought an action before the General Court for the annulment of the measures concerning them. And by judgment of 13 September 2018, the General Court dismissed their action. And I'm referring here to the case which was prior to the appeal, so case D715/14. The companies concerned brought an appeal against such a judgment, and by the court judgment in case C732/18P, the court dismisses the company's appeal in its entirety. As a preliminary point, the court rejects the Council arguments concerning the inadmissibility of certain grounds of appeal because of the authority of res judicata attached to the court's Rosneft judgment of 28 March 2017. Case C72/15. According to the court, even if a judgment delivered in preliminary ruling procedures might be relied on in support of an objection of inadmissibility, the present case is not between the same parties as those involved in the case that gave rise to that judgment, and it could not therefore be held that the conditions governing recognition of the authority of res judicata were satisfied. On the substance, the court has confirmed, first of all, that the export's prohibitions at issue constituted measures of general application, even if, because of the specific characteristics of the concerned sector, the number of actors within that sector was quite limited. Consequently, it found that the General Court was correct to hold that the Council was entitled to confine itself in stating that the reasons for those measures to setting out the overall situation which led to their adoption on the one end, and the general objectives which were intended to achieve on the other, and that the Council was not required to state actual or specific reasons for those measures. What I find particularly interesting is the findings of the court concerning the statement of reasons for the restrictions of individual application imposed on the companies with respect to access to capital market. Here, the court recalls that Rosneft is a major player in the Russian oil sector, whose share capital is predominantly owned by the Russian state. Thus, having regard to the overall situation and the objectives pursued by all of the restrictive measures adopted by the Council, the court has confirmed that the General Court assessment could not reasonably have been, that the companies could not reasonably have been unaware of the reasons why the targeted restrictions were imposed on them. Furthermore, the court notes that both the export prohibitions and the restrictions on access to the EU capital market clearly contribute to achieving the objectives pursued by the Council, and those measures were not manifestly inappropriate having regard to that objective. And afterwards, there are some very technical and peculiar statements as regards the, let's say, compatibility with the restrictive measures with the General Agreement on Tariffs and Trade and the EU-Russia Partnership Agreement. But I will leave you the reading on that. What is important here is that all those frames, all those measures provide for exceptions and provide for the possibility to adopt measures which are necessary for the protection of their essential security interests of the parties concerned. We go now to the latest step in the Ukrainian saga. In this case, we have restrictive measures which have been adopted following the suppression of the demonstrations in Kiev in February 2014. In all those cases, the court noted, first of all, that the courts of the European Union must review the lawfulness of all union acts in light of fundamental freedoms. And while the Council may base the adoption or the maintenance of restrictive measures on a decision of a third state, it must verify that that decision was taken in accordance with the rights of defense and the right to effective judicial protection in the state in question. What I find very interesting is realizing that the court also clarified that while the fact that the third state is among the states which have acceded to the Convention for the Protection of Human Rights and Fundamental Freedoms is can be considered as a relevant factor. And of course, we have also to take a look to the case law of the European Court of Human Rights. That fact alone cannot render the verification requirement of the Council superfluous. The General Court continued by applying the traditional distinction between duty of to state reasons and examination of the merits of the statement of reasons, which goes to the substantive legality of the acts of which the court ensures the review. So in those cases, the court clarified that even though the Council claimed that the judicial review was carried out during the conduct of the criminal proceedings concerning all those applicants, the decisions which had been taken were not capable alone of establishing that the person needed or that it was enough for the person to be maintained on the list of restrictive measures. The court furthermore has referred to the Charter of Fundamental Rights of the European Union, to which, according to which the principle of the right to effective judicial protection includes, inter alia, the right to a hearing within a reasonable time. And in those cases, the General Court found that it had not been established that the Council had assured itself that the Ukrainian judicial authorities had complied with the applicant's rights of defense and his right to effective judicial protection in the criminal proceedings on which the Council had based its decision of re-enlisting. Very interesting case, judgment rendered on the 20th September 2019, Venezuela versus Council. It is a case that brought by a third state, a third country, against a decision of the Council. And in this case, but we will still see what the court will say about it because an appeal is pending. The General Court found that the prohibition which were at stake because of the contested acts were, of course, against natural or legal person, which somehow may have had an impact as well on the overall economy of the country. And as well because the contested measures contained a prohibition on the provision of financial, technical and other services relating to equipment and technology in Venezuela. But the General Court found that those provisions do not impose prohibitions on the Bolivian Republic of Venezuela, and they were likely at the very most to have indirect effects on Venezuela insofar as the prohibitions imposed on natural persons who are nationals of a member state and on legal person constituted under the law of one of them could have the effect of limiting the sources from which the Bolivarian Republic of Venezuela can obtain the goods and services in questions. But of course, the General Court also found that Venezuela was not explicitly and specifically referred to in the contested provisions in a manner comparable to an individual applicant. Interesting it was as well to read which are the differences between a third state who has a field of action that is characterized by extreme diversity and cannot be reduced to a specific activity and therefore is somehow less impacted than an individual person by those limitations. And of course, the fact that a state is called upon to exercise public authority prerogatives does not make it possible to assimilate it to an economic operator, since its modes of action cannot be reduced to a purely commercial activity. It is apparent, however, from the case law that prohibitions such as those imposed by the contested provisions are not likely to directly affect the situation of operators who are not active in the relevant markets. And therefore, the General Court found that the restrictive measures introduced by the Council could not be regarded as affecting as such the legal situation of the Bolivarian Republic of Venezuela, and therefore rejected as inadmissible the application which was lodged. I will just give you this slide to give you a brief overview of the latest Syrian case which has been rendered by the Court of Justice, several appeals. Same here for when it comes to the Iran measures, and a list of recent General Court judgments in the Congolese series. About those cases, just allow me a brief word, because I believe that there is an interesting precision coming from those cases. We all know that the case law states that if the reasons for enlisting have not changed, there is not necessarily the need for the Council to hear again the concerned persons, because if the situation is the same, even though in case of maintaining the measure, the surprise effect is not at stake anymore, there was not such an obligation. However, in those cases, it is held that even if the reasons for enlisting can be the same, and in that sense, the Council may not rehear the person, if the facts are different, and if facts have changed, then in this case, the Council may have the obligation to hear the person again. This did not make a difference in those cases, but I believe that this precision is anyway very interesting. Coming now to the second type of action, the action for damages. I have chosen this recent case of judgment of the last 6th of October 2020, in case Bank Refah Kargaran versus Council. It's a case, his name speaks for itself. It's not the first case we hear about Bank Refah Kargaran. In fact, its origins can be found in 2010 and 2011, when the financial funds and resources of this bank were frozen in connection with the restrictive measures introduced by the European Union in order to compel the Islamic Republic of Iran to end proliferation-sensitive nuclear activities and the development of nuclear weapon delivery systems. That freezing of funds was effected by the entry of the bank on the list of entities involved in nuclear proliferation. And in 2013, Bank Refah Kargaran obtained, on the ground that the statement of reasons provided for by the Council was inadequate, the annulment of the measures which concerned her, and this was case T2411. And in November 2013, the name of the bank was re-entered on the list on the basis of an amended stated statement of reasons. In this case, of course, Bank Refah Kargaran applied again, asking for the annulment of the new measures, but the General Court did not uphold the bank's action for their annulment. On 25 September 2015, Bank Refah Kargaran brought a new action, and this time seeking damages from the European Union for the harm caused, in its view, by the adoption and maintenance of the restrictive measures concerning it, which were annulled in the previous judgment of the General Court. In a judgment of 10 December 2018, in case T55215, the General Court firstly declared that it had no jurisdiction to hear and determine an action for damages for the harm allegedly caused by the adoption of common foreign security policy decisions under Article 29 TEU. And secondly, insofar as the action for damages for the harm allegedly caused by the adoption of the contested regulations under Article 215 TFEU, the General Court dismissed that action as unfounded on the ground that a sufficiently serious breach of a rule or law had not been proven. It was in those circumstances that Bank Refah Kargaran brought an appeal before the Court of Justice, seeking in essence to have the court invalidate the assessment of the General Court on the merits of the action and to rule on the merits of it by granting the appellant the form of order sought. In the judgment at issue now, the court has dismissed the appeal, finding, however, that the General Court had erred in law by declaring that it lacked jurisdiction to hear and determine the action for damages for the harm allegedly suffered by the appellant as a result of the common foreign security policy decisions adopted under Article 29 TEU. In the first place, the Court of Justice examined of its own motion the question whether the courts of the EU have jurisdiction to hear and determine an action for damages in such cases, and it did so as a matter of public policy. In this case, the court held afterwards, on the one hand, that the General Court was fully entitled to declare that it had jurisdiction to hear and determine the claim for damages for the harm allegedly suffered by the appellant as a result of the restrictive measures taken against it pursuant to regulations based on Article 215 TFEU. But the court found that the General Court erred in law by declaring that it lacked jurisdiction to hear and determine that action insofar as the harm allegedly suffered by the appellant resulted from common foreign security policy decisions adopted under Article 29. One has to bear in mind, as far as concerned the CFSP, the rules governing the jurisdiction of the courts of the European Union have, since the entry into force of the Lisbon Treaty, been characterized by an exclusion in principle tempered by two exceptions, one of which relates to the assessment of the validity of the Council decision adopting restrictive measures. Although such exception does not expressly mention an action for damages, the court relies on the necessary coherence of the system of judicial protection in order to interpret the scope of its assessment. From that point of view, the court points out, first of all, that the system of jurisdiction of the EU in matters relating to common foreign security policy diverges from the primary task of the EU courts, namely to ensure compliance with the rule of law. As such, the special scheme must be interpreted strictly. Moreover, insofar as an action for damages form parts of an entire system for judicial protection subject to constitutional requirements, it contributes to the effectiveness of that protection and therefore necessitates an assessment capable of preventing any lacuna in judicial protection and thus of ensuring the overall coherence of the system of that protection. In the present case, the court notes that despite the relationship established by Article 215 TFEU between regulations adopted on that basis and common foreign and security policy decisions adopted under Article 29 TEU, the restrictive measures adopted in legal acts do not necessarily match, so that a lacuna in judicial protection could result from the EU judicature not having jurisdiction to hear and determine an action for damages in respect of restrictive measures provided for by common foreign security policy decisions. In those circumstances, the General Court erred in law, holding that an action for damages for the harm allegedly suffered by a natural or legal person as a result of restrictive measures provided for by common foreign security policy decisions fell outside its jurisdictions. In the second place, the Court of Justice has examined the grounds for appeal put forward by the appellant, and insofar as the Bank Refah Kargaran sought to find that there was an unlawful conduct capable of giving rise to non-contractual liability on the part of the European Union. According to the Court of Justice, the General Court was entitled to hold that the inadequacy of the statement of reasons for the legal acts imposing restrictive measures concerning the appellant was not in itself such as that the European Union could be found liable. But the court added that the European Union may well be found liable where the Council has not substantiated the reasons for the measures adopted in such a manner that was affecting the substantive legality of the measure, provided that a plea to that effect had been raised in support of the action for damages. Secondly, the Court of Justice has dismissed the grounds of appeal brought by the appellant and maintained that the General Court did not err in holding that the Council's failure to comply with its obligation to provide the applicant with the evidence adduced against it, as set out in the judgment annulling the restrictive measures, was as such to give rise to non-contractual liability on the part of the EU. Ultimately, having found that the error of law vitiating the General Court's assessment as regards the scope of its jurisdiction did not warrant the annulment of the judgment under appeal, the Court of Justice dismissed the appeal in its entirety. I believe that a few comments are needed when it comes to this judgment, because since the entry into force of the Lisbon Treaty over 10 years ago now, the ECJ has been invited on several occasions to interpret the jurisdictional carve-outs set out in the treaty provisions. In Bank Refah Kargaran, the court reached its conclusion on the jurisdictional issue in a very definitive way, contrary to Advocate General Hogan, who had appeared slightly more hesitant, in my view, in presenting contrasting arguments in favor and arguments against recognizing the CJEU jurisdiction, in particular the need to take account the wishes of the treaty framers to limit the jurisdiction in the area of common foreign security policy. But, however, the court emphasized now that the Lisbon Treaty has changed the very structure of the EU treaties. The common foreign and security policy had been integrated into the general framework of EU law, and EU had been endowed with a single legal personality. Is all this reasoning persuasive? One can respond that the court is a bit selective in its reading of the Lisbon Treaty. Surely the treaty framers normalized the common foreign security policy in certain ways, including by doing it away with specific common foreign security policy objectives. And there are, however, many indications that the framers of the Lisbon Treaty simultaneously wished to constitutionalize a policy of keeping the CJEU out of a policy area perceived as being too closely related to national sovereignty as the common foreign security policy. In that regard, Articles 24 TEU and Article 275 TFEU could not be clearer. Some may say that the court pushes its teleological approach to treaty interpretation too far. I disagree because I believe that accepting that the EU treaties exclude the CJEU jurisdiction on this issue would in some instances imply that individuals have no remedy against an infringement of their rights. Advocate General Hogan mentioned that national courts are not the appropriate forum for individuals to obtain damages, since member states are obliged to enforce common foreign security policy decisions. And furthermore, courts in some member states may very well refuse to exercise jurisdiction. There is thus no guarantee that member state courts will fill the jurisdictional gap left by the EU treaties. And this could create a potential gap in the EU complete system of remedies and procedure, which in a union governed by the rule of law should indeed be considered unacceptable. A few closing words on the new issues which may still come up. I believe that there is an interesting case right now pending, which I would suggest you to follow, a case 300-2219, El-Khedafis versus Council, where it is questioned which is the dies a quo to calculate the time limit for lodging an application in the absence of an individual notification and in the absence of a publication of a notice when the Council decides to further enlist a person, and the contested acts do not provide either for such notification nor for the publication of such notice. Another interesting case which was rendered yesterday, so it's in joint cases C7219P and C14519P, Saleh Tabet versus Council. interesting reading because it reaffirms the authority of the Azarov case law and the obligation of the Council to verify that a decision is taken in accordance with the rights of defense and the right to effective judicial protection of the applicant. So I believe that, as a few words for closing my presentation, I think that there are a few questions that still remain open and that there are recurrent. First of all is the political assessment of the Council. Sometimes we read in the written pleadings of the party that it is a political assessment for the Council to decide whether a person is enlisted or not. And this political assessment should not be subject to judicial review. Second, each and every case is specific. When, of course, we all know the rules for notifications of the measure and how the Council needs to go further when it comes to notification. So how a restrictive measure, a decision and a regulation adopting the restrictive measures need to be made available to the concerned people. But of course, there are still opening questions, like, for instance, this new issue which is coming up because the contested acts do not provide for an obligation to notification or publication. Another interesting topic is as well to find out whether what constitutes a fundamental and a strong basis for the factual and legal purposes for the inclusion of a person on the list, which is of course subject to the legality revision from the General Court. Although there are several cases that apply the consolidated case law, it is, however, very interesting to see how each and every time there are still few new developments or new precisions, and I'm looking forward to hear and see what the further developments will be. Thank you very much for your attention.